Hello, this is IP Stories by 4IP Council, a podcast about innovation and intellectual property. Join us and you'll hear about the journeys through invention, creation, and IP understanding of our guests.
Dear listeners, this interview is the second part of a longer conversation we had with Harrie Temmink. We decided to split it to make it easier for you to listen to it, as we know that sometimes it's difficult to find that amount of time for a podcast. If you haven't listened to the first half, we recommend you do. There, Harrie talks about the harm and danger of counterfeiting and piracy, especially in the digital context. It was published on the 6th of June 2024. In this second half, Harrie talks about the opportunities and challenges of AI in regards to IP rights. He also talks about the future of IP enforcement and gives great advice to entrepreneurs. I hope you enjoy it.
Those are great initiatives. Thank you for highlighting them, putting this all together for our listeners. As I mentioned before, industries are changing. New generations are creating content in new ways with increasing AI, artificial intelligence usage. Do you think that this creates opportunities or threats for content owners, or perhaps both?
When we talk about artificial intelligence, which is the buzzword of 2023 and beyond, I would say,
Absolutely.
I think that, well, first of all, is it creating opportunity or threats? I mean, there is nobody in this world who will deny that it is both. And that's like with all new technologies that we have seen in the past. All new technologies create opportunities and challenges. And it's not different for artificial intelligence. And in particular, of course, which is the key buzzword, is generative artificial intelligence. They can have tremendous advantages for society. They are not new. Artificial intelligence already exists for more than 30 years. We know them from help desks, from search engines. It's nothing new, artificial intelligence. All big tech uses them already for a long time. But the potential impact, of course, of generative artificial intelligence is impressive. And I think that is something that the listeners will know already, since in particular ChatGPT became a household name. And that was, I think, launched in October 2022. Mm-hmm. So it's relatively recent that we see artificial intelligence being on the front page. I wouldn't say every day, but very regularly. Now, let's first look at the opportunities. Mm-hmm. Now, I am working now for the EUIPO. That's an IP office. Mm-hmm. What we see in the EUIPO is that for operations, we are increasingly using artificial intelligence. Mm-hmm. For translations, for instance, you can use artificial intelligence. For searches, you can use artificial intelligence. And we go beyond that. I mean, we have already projects that we are making first drafts of rather standard answers to standard applications for designs, for instance, that the first draft is done by artificial intelligence tools. That's nothing unique in the world. It happens in the EUIPO, it happens elsewhere, but let me remind you that last Friday, the EUIPO has been rewarded once again as being the most innovative IP office in the world. And so we will certainly develop further in artificial intelligence technologies. Yeah? That's inevitable. Then outside the IP offices in the IP world, the courts are increasingly making use of artificial intelligence, making summary of decisions. Piece of cake today. Law firms, of course, are using artificial intelligence already for some time to do a risk assessment before they advise their clients. How big is the chance that I will win this case when I go to court or not? That's normal business. If we look at the regular business, not the legal businesses, but the real businesses, then we see in the cultural industries, for instance, that they already massively make use of artificial intelligence to create content. For music, for fine-tuning music, for polishing music works, for audiovisual productions, artificial intelligence is used all over the place. I recently understood that there is not one single ad for cars anymore that is actually made on location. So each and every car ad that you see, publicity from car manufacturers, it's all done by artificial intelligence, actually, using virtual tools, right? So it's normal business already. And then if we look at a positive aspect of the use of artificial intelligence to identify infringements, well, let me give you a figure that can be found in the latest Amazon brand report, which was published, I think, in February. So whereas we are focusing a lot about notice and takedown procedures, we want to have decent notices to e-commerce platforms so that they can take down illegal listings, illegal offers of counterfeited products. Well, in practice, that for a company like Amazon does not represent more than 1%, even less than 1% of all the listings that Amazon claims they are removing or even not showing to the customers. So 99% of all the potential offers with counterfeited products is taken away already, removed as a preventive measure on the basis of artificial intelligence. 99% and possibly even more. And I know from other big tech companies like Google, the Google search, it's probably 99.9% what you do not see, because it would be illegal content. It would probably be more than only classic IP infringements. It will probably be any illegal content, but most of illegal content that you and I don't want to see, we do not see because big tech companies already invest in artificial intelligence to avoid that. Well, I mentioned already the positive sides, but there are inevitably also negative side of the use of artificial intelligence for the protection of IP rights. I will start with the element that is less visible in the media or in the specialized press, and that is the fears that we note increasingly of brand owners that their brands, their trademarks, their signs, their designs are used by the models to train artificial intelligence systems. Yeah. So for copyright, we know it already for quite some time, but we see that increasingly brand owners are getting worried as well. For brand owners, we still have to do a lot of research to see what exactly the problem is and what we can do to avoid their genuine concerns and their legitimate concerns that trademarks, designs are used actually by artificial intelligence models. Now, we have a little bit more experience with copyright, as you know very well. Copyright is at the forefront in this whole discussion about IP and generative artificial intelligence. Copyright holders are concerned because their works are used as training materials. We already have seen many legal actions, not so much in the EU. We have seen it in the UK more than in the rest of Europe. But we see that in particular in the US, and we are following that very closely because obviously there are concerns that the protected works are fully or partly copied, mimicked even by generic artificial intelligence service, the deep fake story. And it is not only linked now to text. We also see increasingly the use of images, of sounds, of anything you can imagine is used by artificial intelligence models. And all of this can lead to a potential infringement of copyrights, right? Now, if we look at what is done about that, well, we go back to the Artificial Intelligence Act. As many of you will know, it imposes new obligations on providers of the general purpose artificial intelligence model. So not each and every artificial model, but the general ones, the ones that are broadly used by people, I would say, by the public at large. Sorry. And there are two obligations. So the first obligation is that these developers, these service providers of general purpose artificial intelligence models, they have to put in place a policy to respect EU law on copyright. And there we refer in particular to Article 4 of the Copyright in the DSM Directive, which is the so-called text and data mining exception when works are used for text and data mining. So the system goes as follows. Article 4 allows companies to use copyright protected works for text and data mining. However, the owners of the rights are entitled to opt out, but they have to express that, of course. And the question then is, well, how, in the context of artificial intelligence, can you, as a right holder, express that you want to, that you do not want your works to be used, or at least that you want them, that if your works are used, that you only want to allow that when there is a decent license agreement signed. So it's not only about prohibition, it's also about a fair remuneration, which is another key element of the copyright in the DSM directive, right? So this is the first part of the artificial intelligence important for the copyright owners. So the developers have to have a policy in place. They have to explain through state-of-the-art technologies that they do respect the right of right holders to opt out under Article 4 of the Copyright in the DSM Directive. So that's one part. The second part is more focused on the output. That is to have a summary made about the content that they use actually for the training of the general purpose artificial intelligence model. So they don't only need to respect the copyright, they also have to explain what kind of content they are using that is protected by copyright in their training models. Yeah. And the other thing is, of course, that there have been voices raised already in Brussels and outside Brussels that it would perhaps be useful if we could have a portal, a depository where right holders can express their intention to opt out or to opt out under conditions. We don't have all the solutions today. There is a lot ongoing. Every day there is a new development, there are new cases, etc. But we at the EUIPO, we stand ready to support everyone with technical means to help them protect their rights and to do legitimate business.
Yeah, I can imagine that the implementation of the Artificial Intelligence Act will be a big challenge from what you say. So we are looking forward to see how that happens. So I want to talk a little bit about the EUIPO actually. It was created 30 years ago, right? And a lot has changed over the years. One could say that IP rights have never been so important for Europe. So I would like to know, from your opinion, how do you foresee the evolution of IP rights enforcement in the coming years?
Okay, well, again, if we have an hour for this, in addition for this podcast, then I would be very pleased, but I'm afraid we don't have that. So I'll try to be as succinct as I can. But I have to focus then, if you look at the evolution of IP rights enforcement in the coming years, I think I have to focus on several dimensions. And we have a technical dimension, we have a policy dimension, and we have a legal dimension. And let me say briefly something about the three elements, right? So technically, I think it is absolutely clear, also based on the previous answers, that new technologies in the digital environment are a game changer when it comes to IP infringements and when it comes to the enforcement of IP rights. We discussed generic artificial intelligence already, generative artificial intelligence already. I don't need to do that anymore. We discussed already new innovative artificial intelligence tools to identify counterfeits on e-commerce platforms. We mentioned it already, right? But we should also look actually at technicalities when it comes to automatic content recognition tools. We see an improvement of all sorts of tools, image matching, printing technologies, to verify the authenticity, of course, of a product, holograms, barcodes, watermarking, what have you. The systems become increasingly innovative and modern. And perhaps I should also refer to the blockchain technologies. As some of you may know, the EUIPO has been very active in the development of blockchain technologies in the context of the fight against counterfeiting. We have a project running, a blockchain project running, together with the European Commission and together with right holders, with customs authorities, and with logistics. It's up and running as we speak, and we hope that the results of that project will become increasingly mainstream, in particular when it comes to right holders who want to protect their products against falsified products. And I think we are doing a great job there too. Now, this is the technical part of the story, the future, the evolution of IP rights and IP rights enforcement. Then when we look at policy, I think first of all, and this is relevant both for counterfeiting and piracy, I think there is an increasing awareness about the vital role of online intermediaries in the fight against counterfeiting and piracy. This role cannot be underestimated. I spoke already about the crooks, the criminals, but I should also refer to the broad range of actors which should be encouraged to do more. And I'm referring to the world of the domain names, the payment services, the payment service providers, the social media, the providers of logistics, the providers of online advertising, the providers of search services, etc., etc., etc. And the EUIPO is doing a lot in this context. We publish on a regular basis so-called discussion papers where we set out the ecosystem of a certain intermediary, and we look at the trends, and we look at the good practices. Now, this work will be ongoing in the EUIPO, yes, but I should mention here as well another element which is very much a game changer as far as I'm concerned, and that is the implementation of the Digital Services Act, which has come into force, and the Digital Services Act has come into force entirely on the 17th of February of this year. And when it was adopted in 2022, I remember very well that a big part of the let's say the IP industries were disappointed. They were very much disappointed, not so much when it comes to the proactive measures that digital service providers have to take to avoid, to act against infringements online, the notice and takedown procedures, which we have now very much harmonized, unified at EU level. But in particular, when it comes to the preventive measures and the fact that there is hardly anything on IP right infringement at all. Now, what we see happening in practice is that the European Commission has new tools on governance under the DSA. And it means that the European Commission, like it has tools to do competition policy, like it has tools as well in the area of the GDPR on data protection, now when it comes to control, in particular the big tech, when it comes to the dissemination of illegal content, including IP infringements, the Commission has much more tools together with the member states than they had before the entry into force of the DSA. And I think what we will see in the future is that the Commission is going to use that power to force, in particular, new players, big platforms, such as Shine and Temu, who are the new kids on the block in the EU, that they will use their powers actually to force these big tech players to do more to avoid that counterfeited and pirated products are being offered online. And I will refrain here from going into the details. I will only refer the readers who are not aware of this all to the website of the European Commission, where on the DSA implementation you find a lot of very useful information on where we are with notice and takedown procedures, trusted flaggers, know your business customer, transparency requirements, but also the new rules for the so-called flops and the flows, the big techs that we are having. Yeah. Okay, so the DSA implementation is something to really follow closely. Even if you are a hardcore IP expert, you are no expert if you do not know how the DSA is working today. And then, of course, I can also refer more copyright specific to the implementation of the Artificial Intelligence Act, to the implementation of the copyright in the DSM directive, in particular, of course, the opt-out mechanism of Article 4. And I can also refer to the two recent Commission recommendations and their follow-up. We have the live event piracy recommendation of May last year, where we, together with the European Commission, are monitoring the process to see how we can better combat live event piracy. And there is also this new recommendation of the European Commission to combat counterfeits from DG GROW in the lead. And we are doing a lot actually to monitor together with the Commission also the way that member states, but also right holders and intermediaries online are taking these recommendations seriously. Yeah. So this is all policy-wise, I would say. And then, last but not least, what about new policies? What about new legislation? Well, there, of course, we have a new cycle coming up, a new commission that is going to be appointed in the last months of this year. And when there is a new commission, we all know that the officials in the European Commission have to work and prepare new policy measures, including in the area of IP, including in the area of IP enforcement. And what can we expect maybe over the next years? Well, I think we might see more pressure on the Commission to revise IPRED, and in particular when it comes to the use of dynamic injunctions, which is a phenomenon that we see increasingly happening in member states, and we support that very much. But also, of course, we might see a revision of the customs regulation, the IPR customs regulation, in the context of the customs reform. And who knows, maybe as a follow-up to the two recommendations that I just mentioned, maybe there will be legislative initiatives as well as of that. And last but not least, within the EUIPO, I should mention as well that we are working on the Strategic Plan 2030. The draft of that strategic plan is discussed with the members of the management board on the 5th of June here in Alicante. And so I can't say much about that, but stay tuned also on this, because the EUIPO is going to do more on innovative models and also on ways to protect IP rights. Voila. So a lot ahead of us. You will not be without work there as watchers in Brussels, I think.
So, Harrie, to conclude, what intellectual property rights advice would you like to give to young European entrepreneurs creating their startups, either in e-commerce, creating products, or services?
Okay, yes, well, I think I can be pretty short here in my answer. I would advise them, first and foremost, be aware of the value of your crown jewels. Protect your IP assets. Protect your rights. Be aware of your rights. Explore ways to manage your rights. Register your rights. And be prepared as well that something may go wrong. So have a policy in place already to enforce your rights when the inevitable happens.
I think that was great advice, Harrie. Thank you so much.
It was nice to do this podcast. Thank you very much.
Thank you so much, Harrie. It was great to have you here with us today.
Thank you for listening to IP Stories by 4IP Council. Visit our website on 4ipcouncil.eu to find out more and check out the links mentioned during this episode. If you liked it, remember to share and subscribe.